Hello, good morning, and welcome to another episode of The Legal Zone where we tackle injustice. We have an amazing show today. I'll get to the guests in a minute, but let me do my introduction. My name is Salon Phillips, your host, and with me I have the lovely Dr. Cheney. Good morning, Dr. Cheney.
Good morning.
And Mr. John Salati. How are you today, John Salati?
Always good to be with you, Mr. Phillips. Always good to be here.
Always glad to have you. Now, let's start off with a little legal nugget as we usually do. We've talked about this in one of our earlier shows. I think it was actually the very first show when we had our guest on it. For those of you who may be new to the show, we started with having actual clients who were going through an injustice. And they came on the air and they talked about whatever injustice they were going through. And to prep them, we would remind the guest of this one little word, defamation. And we went over the elements of defamation. So let's quickly go over them again. For all of you all studying, you law students, remember this because just about every bar exam has at least one defamation question, at least one. The elements are a false statement purporting to be a fact. That's you say something as though it's true. A false statement purporting to be a fact. 2, publication or communication of that statement to a third party. If you're in your room and you're saying some stuff that's not true and there's no one in the room to hear you, can't really be defamation. It has to be delivered or communicated to a third person. Then the third is fault amounting to at least negligence. That basically means that the person who said or wrote the false thing didn't take the time to find out whether or not the statement was true. You know, sometimes people love to run and go tell stuff that they heard at the barbershop. Right? You might be found liable in defamation if you follow these three, if these three elements fall in play. And then lastly, there has to be some sort of damage. Okay. Defamation. And I open with that because our guest today has tons of experience with this. His name is, I'm going to share the screen so we'll be on the gallery. His name is Raees Mohamed. He is one of the co-founding partners of RM Warner Law Group. And he's also an adjunct professor of law at the Sandra Day O'Connor College. He has been practicing law in Arizona since 2009. Raees works with complex legal matters such as internet, corporate, regulatory, and technological legal issues in all 50 states of the United States. His practice is avidly devoted to helping those facing injustice through internet harassment and defamation. He also helps new entrepreneurs with their startups and their own e-commerce brands. Welcome, Mr. Raees Mohamed. Thank you so much for coming on.
Yeah, thanks for having me, Salon.
So tell us a little bit more about you and what you do.
Yeah, so thank you for the amazing introduction. But yeah, as a founding partner of RM Warner Law, you know, I had the e-commerce and corporate law practice, as my partner Dan does as well. And you know, 90% of our work touches the internet in some capacity. And so the interesting thing is you tell people nowadays, hey, what kind of law you practice? And you say internet law. They have no idea what you're talking about, but they don't realize that the internet is this wild, wild west domain. It's its own world. And so we are well-versed in tackling all the issues that happen with being online, doing business online. And you mentioned some of those, right? And one of the most prominent issues our clients face is internet defamation. And getting their reputation rehabilitated online is a major part of our practice. And most of that is plaintiff side work. And we could talk more in detail about what that is. But on the other side, we have our e-commerce and entrepreneurship practice, right? So you have somebody who might be starting an online brand, launching an online store. We have attorneys as well who are launching their brands online, and they need kind of the 1, 2, 3s of what do I need to do to get started to protect myself Particularly with the e-commerce brands, it's really interesting, influencers using TikTok and Instagram and scaling their law firms even to 7-8 figures.
Now, what is an influencer? I've heard that word before. What exactly is an influencer?
Yeah, I think a lot of people have their own definition. To me, an influencer means somebody who has some level of clout on social media, some level of a following, and is promoting some product or service.
So it's people who you see these people on Instagram and they have millions of followers and they have some sort of, as you said, clout. That's an influencer, basically.
Yeah, basically. I mean, in the high level definition, that would be an influencer.
Okay. Now you mentioned that you do things, you have clients in all 50 states, because with the internet that can become dicey, right? With lawyers they have license in a specific jurisdiction, but then when you deal with internet, I mean, it could be even international.
That's exactly right. So, and we have clients internationally. We have clients, in Asia and the Middle East, Mexico, Canada. We have clients from everywhere. But that's exactly right. I mean, depending on the issue, many of these issues are, for example, in the States, they're federal issues. There might be copyright law issues. There might be FTC issues. We're well versed in the laws relating to defamation in different states, but internationally as well.
So, give us an example of what exactly can go wrong with a client, a real life situation. Of course, you'll protect the people's names and what have you, but educate us on that.
Yeah, I mean, I have stories to tell from now until how much time you got, right? I mean, it's an unbelievable world online. But, most recently, we've seen an increase in false Me Too allegations, which is a big deal. And it goes both sides for either gender. But mostly cases involving prominent men, at least prominent in their circle, who have been accused wrongfully of some sort of assault, whether it's sexual in nature. Typically it is sexual in nature. And the problem with these cases is obviously they're very controversial, because immediately any allegation of sexual misconduct needs to be taken seriously, right? It has to be investigated.
Right.
But therein lies the double-edged sword, because it's very easy to get attention by using buzzwords like, I was touched inappropriately, I went on a date and XYZ thing happened, and this guy's a pervert, he's a rapist, he's a predator, and the words escalate, and we come to find out there's no basis for it. And sometimes that comes out through an admission by the alleged victim that it was a fabricated story, it was exaggerated, or that in fact it was consensual, that the person talked about it with other people, and it has a devastating effect on your reputation. You can imagine, regardless of what profession you are. If you're an attorney, you're an influencer, you're a medical doctor, you're a financial analyst, doesn't matter. Those kind of allegations are devastating. So we've seen an increase in this kind of activity. And it's interesting, TikTok and Instagram are the primary platforms on which that's happening, because those platforms, things tend to go viral a lot faster. In fact, more and more so TikTok than any platform.
Yeah.
So, we had a case where we've had several cases where that's exactly what happened. And the gentleman's life was completely just devastated, and went viral. He had to change his identity, essentially. He had to skip town, move to a new state. And the girl admitted that this was fabricated eventually in litigation, during the course of litigation, eventually admitted that,
So how do you get to that stage? Somebody comes and they come to you and they say, hey, I'm being accused of touching a little 12-year-old girl. And what's the first thing you do?
Yeah, and that's actually a good example to start from, because there's some cases we just don't take. and so if there's minors involved, again, it depends on how comfortable we are. We're not going to just take any false allegation, right? So in your example, we would say, first of all, we may not take this case. What happened on the criminal side? Is there a criminal complaint pending? What was the outcome of that case? Obviously, there's implications. But we need some form of evidence, somebody who's going to back the story, who's a witness, what happened, what were their motivations for doing this kind of thing. So picking the right case is important, right? Consequently, you don't know. It's very early. Somebody comes to you. If all they have is a he said, she said, we generally don't take those kinds of cases because of the burden on a plaintiff in a defamation case, right? And so, it really depends on the facts. Some of these, like today's society, particularly in the younger generations, but even older generations, they say things after their experiences online and in text messages to other people. So when there's documentary evidence of these kinds of things that controvert what the victim's saying, those are the kinds of cases that make sense to take.
Okay, but before you get to that, you actually have to do some sort of investigation, I'm assuming that.
That's exactly right. And so with defamation cases in particular, but in any case, you're an investigator first before you're an advocate, right? So before you get into a case and before you advocate for your client, you need to know whether the facts you have are the facts. And
that is so important. Any young attorney listening, please say that to them again, because so often they'll have a client come to them and say, oh my goodness, this happened to me, that happened to me. They'll jump, they'll sign a retainer. And then once when they're in it, they find out that everything that was said to them is false.
And see, this is where it's a heightened level of scrutiny on us, particularly as defamation attorneys. I mean, think about it. Oftentimes you're targeting something that went viral online. Do you want to be on the wrong side of that if it turns out that you didn't have the right facts?
Right.
And it can have devastating consequences for the attorneys. So yes, I agree. You have to investigate first. It doesn't mean that you're not a good advocate. It means you're being a good advocate by questioning everything. I mean, that's a requisite part of being an attorney is, listen, I want to believe you. Thank you for coming to me. But we need the facts because we have to present this case. This is not just suing somebody. You have to have the diligence. We need to have all the rocks to build the wall, right? We need all the mortar and everything to do. And I can't do that on your word alone, right? I mean, it just doesn't work. It doesn't work like that. You slip and fall in a grocery store. Nobody hands you 10 grand to go away, right? Like people used to think this way because of the TV shows and the overhype of just suing somebody and getting money or getting them to shut up. That doesn't work anymore, right?
So with the internet, somebody puts something online and you do your investigation and you find out that it's 100% not true. So you take the case. Then what do you do to get to correct that injustice for your client?
So it depends on the scope of what we're looking at, right? And so I'll give you an example. We had a client who today has been defamed for a total of 6 years on and off by a former employee. And this guy's being accused of murder, like being an accomplice in murder. A big deal. Yeah. Oh. And he's a prominent guy. He's a wealthy guy. And this campaign has gone on for 6 years, on and off. So client comes to us, we vet, we interview the client, right? We have either an in-person consultation or a video consultation like this. And a trained defamation lawyer knows that you have to ask the right questions. The quality of your answers are only as good as the questions you ask. You've heard this all before as lawyers.
Yes.
And so you don't say, tell me what happened. I mean, you can, but you have to be very chiseled. So listen, this allegation that you were here on this day, let's start there. Were you there? It's almost deposing this person who's going to be your prospective client. Okay, you were there. Who can vouch that you were there? All right. You texted this person. I have a copy of this text you sent me. And generally we ask for documentation, right? During the consultation, we'll say, look, produce us links, give us names. We go through the whole Q&A that we can possibly go through. And then we tell them, listen, if you want to move forward, we typically start with a demand letter. We don't rush to the courthouse. And that gives us an opportunity to flush out the facts more, right? Because what happens when
what's a demand letter? What do you mean when you say you give who a demand letter? What is that?
Yeah, so once we figure out who the potential responsible parties are in the picture, in the defamation scheme, we then get more documents, screenshots, recordings, whatever the client can give us. And then we start drafting a letter that's typically to demand the person to cease and desist, right? To stop doing what they're doing or make some form of corrective action. I have a case right now where a reality show girl went on several different podcasts and is going on a comedy tour defaming her ex, and who's a very prominent person in the community, right? And so the point is, I want to hear the podcast clip. I want to see the pictures, right? Give me all that. We send a demand, like you said, a demand letter, something to insist that, look, you need to stop doing this, Mr. or Mrs. Defamer, and these are the reasons why you need to stop. This is who we are, and this is how much in damages we're going to seek. And here's some evidence of it. And attach screenshots, include a link, something with real teeth. And that also helps our client understand the level of scrutiny that we like to have as defamation lawyers. Because we ask for a lot, and our demands are 4, 5, 6 pages sometimes without exhibits. They're very detailed for that reason. So, depending on the issue, if you're an average doctor and you have a false Google review, and it's truly false, patients accusing you of malpractice, for example, or of insurance fraud, which is a common thing that disgruntled patients do. Usually it ends at that point because the patient realizes, I screwed up. I should probably delete that. Let me at least take it down.
So
and it ends.
So you deal with negative reviews on Google, because that's huge.
Yeah, absolutely. We get a lot of calls, particularly from professionals, doctors, dentists, other lawyers. And we do the same level of scrutiny. Is the statement false? Or is it a truthful statement that you just don't like? Because we can't help you if it's true. Right. Your office staff can handle that. Call up your patient, offer them a refund, right? Give them a gift card. But if it's false, then yeah, come to us and we can find a solution for you.
Interesting. Dr. Cheney, I'm going to get you in really quickly.
Okay. Hello, attorney.
Hi there.
Got 3 questions for you.
Sure.
In this country, we have the Constitution, right?
That's exactly right.
We have freedom of speech, freedom of the press, etc. We have defamation laws. I'm always interested in comparison, just a little bit here. What about other countries with different cultures? Do the elements for a defamation claim vary according to these different places?
Yeah, that's a great question. And they do vary. The elements do vary. In certain countries, particularly in Asia and the Middle East, you may not need to prove actual damages. The fact that something was said that you allege was false, speaking purely of defamation, sometimes that itself is enough. In other countries, it may be okay. Like I think, for example, in Dubai, even, it may be okay, even if the statement isn't actually false or provably false, but it was in a harassing way. Now we're shifting gears into harassment, which is slightly different. That has implications. Sometimes it's criminal implications. In the UK, for example, they don't have a First Amendment. And they don't have this concept of, in the United States, we have this federal statute, Section 230 of the Communications Decency Act, abbreviated as CDA. Section 230 is what gives immunity to Facebook, Google, Twitter for statements by other people, right? Mm-hmm. So this is a time-tested principle in America because we don't want to create liability for these platforms unless it has to do with, trafficking or child pornography. Absent that, these platforms have no liability. You don't have that in the UK. So technically, Twitter and Google and these platform websites, they can be held liable for third parties' content. Very, very different here, right? And that's why we struggle sometimes as lawyers to get cooperation from these platforms, because essentially it comes down to whether they want to enforce their own terms. So it's a great question. We deal with this issue, and it can be very complicated and frustrating for people who may be dual citizens or have a business in the US but are in Europe, right, or in Asia. It's a problem.
Okay. All right, you mentioned a little bit about this. In 2006, a lady out of New York City named Tarana Burke started the Me Too movement. For this question, I borrowed from a New York Law Review article by Shiana Westbrot Cuny School of Law. And the volume, if anybody's interested, is 22, fall 2020. That kind of thing is the source information. The article covers a great deal about the 2007, even though she started in 2006, Me Too movement. I am lost, right? Oh,
We could see you.
really?
We could see you and hear you. Yeah.
Okay, I can't see you all anymore. The article covers a great deal about the Me Too movement and the legal ramifications for defamation. I want to talk about SLAPP and anti-SLAPP defenses, and it's covered in the article. SLAPP is defined as strategic lawsuits against public participation, or SLAPP. To counter the accuser files an anti-SLAPP defense. Are you with me on that?
Absolutely.
Okay. Do you think the SLAPP and anti-SLAPP defenses emerging from the Me Too movement, and if that is the case, did they emerge from the Me Too movement against defamation, scares accusers into coming forward?
So the intersection of Me Too, especially, and anti-SLAPP is extremely, extremely interesting and very dangerous. And so to answer your question,
Yeah.
I think the anti-SLAPP laws give an incentive for victims to come out and tell their story, because it rewards people who are being sued if you're a defendant, but you are speaking something that is protected speech. And I have dealt with this issue. For example, Nevada has a very, very, very strong, Nevada and California. In fact, California, I think, was one of the first in the country to enact an anti-SLAPP law. And New York has also had a very, very old statute. But the idea that is that, so your audience understands, the anti-SLAPP is a 100% defense strategy that says, not only do I get to dismiss plaintiff's lawsuit early with prejudice, so basically it functions almost like a summary judgment motion. It's you look at outside facts. Normally on a motion to dismiss, you would not look at outside facts, right? With rare exception, like on personal jurisdiction. But with the anti-SLAPP motion, we actually get affidavits in, we get testimony in, we may have a hearing. And so it allows people who are, even if they're not necessarily true, but it's protected speech. And this is where it gets really interesting. If it's an opinion that you had in good faith, if you're a third party who maybe was told, hey, XYZ person believes they were raped and I'm reporting on it. They're not the victim, but I'm reporting on it. And I talked to her and I believe that she was in fact raped or sexually assaulted or touched in a non-consensual way. I have substantial immunity from that if I believed in good faith that the statement was true, which means a plaintiff's attorney, even if the person who's speaking is wrong, plaintiff's attorney will lose their case at the pleading stage. So yes, it allows people who are victims or who have knowledge of these facts to come forward and speak in good faith. And again, there's certain protected classes of statements, and speaking in good faith on a public issue is one of those protections.
Okay. And this is my last one, a hypothetical one, taking you back to school, okay? Imagine a court case where an attorney makes untrue remarks about the opponent's client, as the goal is to win the lawsuit at any cost. Some say it's fair game. It's all about winning. My question is, should clients expect a little verbal abuse and embarrassment, as this is what happens in US courts?
That's a really good one. And in fact, we don't even have to make it too hypothetical, because Johnny Depp is being sued by Amber Heard's lawyer for this exact thing, because the lawyer as an agent spoke to the press saying that Amber Heard's case was frivolous and malicious and done to extract money, had no basis, et cetera, expanded on some specific words. And a cause of action is viable because statements made in a legal proceeding, in fact, are generally privileged. They're generally absolutely privileged because
What does that mean exactly?
in that, I'm going to get to that exactly. So absolute privilege applies when somebody has a duty to speak, generally has a duty to speak, or is otherwise speaking in a context in which we expect them to make statements that may not always be true. And a legal proceeding is exactly, that's why a witness who's testifying on their observations, even if it turns out to be incorrect, is not necessarily going to be held liable for defamation. And this applies to lawyers as well. We draft documents, we file complaints with statements all the time. What if we're false? Can any lawyer be sued for defamation? No, generally that judicial or quasi-judicial proceeding privilege applies. But the question was statements made to the press, and that's different. And you are not under an obligation as a lawyer to speak to the press. And unfortunately, lawyers fall into this trap that, oh, I'm fighting for my client. You know, I'm telling my client's version of the facts. Well, no, you're not. You're trying to get press. There's a difference. Lawyers are not under an obligation to speak to the press. So if you speak to the press, you need to make certain you're speaking truthfully. So it's okay to give a synopsis of what you think your case is, right? It's okay to say, I believe my client was harmed, so this is a false statement, and we're gonna try our case to a jury. You could say statements like that, but beating up, throwing rocks at the other side, accusing them of a malicious false campaign, it's a slippery slope, right? If you're saying it to the press, you don't have the same level of privilege you do in court.
So what I'm hearing you say is, and this could go for anyone, lawyers or otherwise, if you're speaking in the public to other people, if you preface your statement with, I believe, or it's my opinion, this guy is a bum, then you're protected because you're giving an opinionated statement rather than a statement of fact. Is that true?
It's true to a degree, because you can still preface, and there's some case law in different jurisdictions on this, but you can even start as, in my opinion, but you can abuse the privilege as well. There's something called the abuse of the privilege, and that's something a jury could get to hear. So if you go too far, then this is very common in these high profile cases, like you're seeing with Amber Heard and Johnny Depp. So again, what you say, so we have lawyers call us all the time to say, hey, can I say this? Can I pay you to review this statement I want to make? It's the smartest thing you could do, because you could cost your client their case, you could cost you liability. So you have to just be careful. Not any one thing is broadly protected always as privilege.
Now, I'm going to turn to John in a minute, but I just had a quick question when we were talking earlier. This whole Me Too movement. So the Me Too is where usually females, and I guess it's not, is it a gender specific type thing?
I think Me Too originated with the idea that, yeah, female victims are silenced, particularly when there's a power discrepancy, like when it's a model producer or actress producer relationship, right? I think it originated in that way.
Okay, so something sexual usually happens to them, and then they speak out and say, me too, this happened to me too. Now, in a case where a female does that to a male, a boss, somebody in power, but it's 100% false, right? And you do your investigation and you see that it's 100% false. You send your demand letter and they stop, the cease and desist, they stop. But then the person who it was said about, they're still damaged. They still are facing an injustice. What can be done, if anything?
Yeah, so we see this issue a lot. And when the perpetrator doesn't have money, for example, to pay the damages, it becomes an issue of a campaign, some sort of PR corrective campaign. So frequently what we do is, in addition to money, if they don't have money, we will ask the defendant, or the person in this case who's admitted, right, that they're wrong, to write a corrective statement of some sort to clear the air. And so we will help them through somewhat of a PR reputational campaign. We'll say, look, this person is now admitted. So as part of my settlement with you, short of trial, however far the case goes, as part of our resolution, we generally, it's our practice to ask for a corrective statement and say, plaintiff gets to publish the statement and you have to publish the statement. For example, on your social media outlet, Facebook. If this happened on Facebook, then we want people who heard and were exposed to your statement to hear that on the same platform. We've had this on YouTube before. And so the non-monetary component of it is the campaign. And that can go pretty far when you have the victim recant, or you have the aggressor, the claimed aggressor, recanting their story, saying, you know what, this wasn't totally true. And I'm sorry.
As the attorney, would you write their statement and they just basically sign off on it and it's like they're the ones who said it? Or would you leave it to them to write it? Because they might write something that's not that convincing.
Yeah, that's a good point. So usually it's negotiated. And typically most of our defendants have legal counsel. Sometimes they don't. But we always put our language the way we want it, what's favorable to our client, right? And we give the other side a chance to edit. And sometimes that takes months. I had a case with the doctor, relating to like vaccine safety. It's kind of like a vaccine and what happened in his office. And that case took 4, 5, 6 months to negotiate the corrective statement because the guy on the other side didn't want to admit he was wrong. He's a medical doctor too. So we had to play this dance of what are we going to put in that statement?
Wow. John.
Oh boy. So much good stuff here. Just want to go back to something you said, Mr. Mohamed, about it is my opinion sort of defense and whatnot and how that impacts people. That made me think of a time when, let's say you're listening to a broadcast and somebody has been arrested. And so at that stage, then the broadcaster would say, oh, John Salati is the shooter in this, blah, blah, blah. And that was often how these things were framed. And then at a certain point in time, I think there was a defamation case of some sort. And now all of these statements then became framed or forwarded with the word alleged, because again, the people saying these things didn't know, nothing had been proven yet. And yet, of course, saying John Salati is the shooter, in this case is very damaging. And I don't know if you could speak to that, but that is a recollection of mine that some kind of a defamation issue came up and now you're almost always going to hear the word alleged in regards to some kind of criminal activity related to somebody or a Me Too kind of scenario.
Yeah, it's interesting because if the question is, hey, what happened, right, that changed that perception and changed the exposure and the ability of somebody to sue, the answer to that is, one of the landmark case is New York Times v. Sullivan, a case that came out of New York State, eventually went to Supreme Court, made some amazing points of law. But it comes out of, it's a 1960s case, I think, and it's, heavily around what happened in Montgomery, Alabama and civil rights. And so it makes a lot of sense in that context because it's, we want to speak about the wrongdoings without any sort of culpability if I'm a news media outlet, right? To your exact point. We're reporting on the facts we have as we know them. So there was a guy that looked like John Salati. He wasn't as handsome as John Salati, but maybe he was close enough. We thought it was John. And so it happens all the time. And so news media in particular, they have, if you're a plaintiff suing news media, which I don't recommend, by the way.
Why?
The burden is much higher. So you have to prove actual malice. And this is what's coming out of New York Times v. Sullivan, because the news media, the whole point is we want information as fast as we can get it, even at the risk of being somewhat inaccurate. And so reporting live on the street, somebody reports it was a white BMW, turns out to be a gray Porsche of the same year. And it turns out we reported it was driven by Dr. Smith. In fact, it was Jane Smith over here. And now everybody's interviewing and rushing. The cameras are on the doctor's office. It's like, I have no idea what you're talking about. I wasn't there. Yeah, the doc probably has no recourse on that, because you'd have to show that, in fact, the news media knew that they were wrong in reporting false statements of fact. That does happen, right? You hear the
Well, the
particular,
recent New York Times case was the Palin case.
right?
We got it wrong, and within a day, they corrected it. And yet, they were sued, and she eventually lost the case on the very point you're raising.
That's exactly right. It's defamation is a very nuanced area of the law, and a lot of people just assume that, hey, somebody said something false about me, I have a great case. I have a great case. You hear this all the time. And with the access to information as easy as it is, and some of these big cases, right, get published on social media. Celebrities winning defamation lawsuits. Oh, well, I should be able to win this money too, right? Why can't I, Raees? Why can't you take my case? Well, no, you have a different standard of proof, especially when media is involved. And we're not really a firm that sues media. We rarely see that there is culpability, and it's for the reasons you suggested.
Okay, let me throw this at you. Salon had mentioned earlier that much of what we do with the Legal Zone is have clients come on or people come on and speak about their personal injustice. And one guest we had come on months ago, very popular show that was somebody who was placed on a sex offender registry. And he was fighting them on this. The state, we'll just call it the state on this, in this case, for that, no, he should not have been on the registry by law. And eventually, 5 years later, they took him off. Yeah, we're going to take you off. You don't meet certain criteria, and so we're going to take you off. But as part of the having you on the registry, so much information gets posted online in those venues. And also they have the police going around the neighborhood where this person lives, handing out leaflets about this particular gentleman. So obviously that's not a lot to go on, but I would love to hear, here's not a celebrity, and but this is an ongoing situation. He's in lawsuit with them right now about the damage done to him, in part because, yeah, you put all this information about me on the internet, and my name, address, social security number, this, that. There's been identity theft problems, this problem, that problem. What does somebody like that even attempt to do?
It's a great question. Typically, let me start with this. We've dealt with these kinds of cases before, and the facts, again, are very important, right? Because truth is absolutely privileged. If you say something true, or it turns out to be true, regardless of how bad it is, you don't have immunity for it. And so there's a little bit of a dance here. Let's say, I'm going to make up these facts because I don't know what the rules are in every state, but let's say you're accused of being a sex offender in Florida. And in Florida, hypothetically, if you look at somebody who's changing their clothes, and let's say they're a minor and you saw something you weren't supposed to see, you could be deemed a sex offender. Let's just run with that fact for a second. Let's say that, in fact, you were in your house, your neighbor's daughter was home, her curtains were open, she was taking a shower that exact time, she came out, she says she was naked, and she says she saw you and you were in your room. And in fact, you were in your house, but you weren't in your room, as you sometimes are, and she's just being paranoid. Well, under those facts, is her belief that you're a sex offender true? And she reports it, In this case, obviously, you should fight that because you're being accused of something you didn't do. You weren't there. You didn't see anybody. You shouldn't be considered a sex offender. You should fight that. If a registry said that you're a sex offender, the registry would be incorrect. But let's move the facts a little bit more. Let's say she reported it to the police. The police report gets registered. Obviously, it's public record. And let's say the state now says this dude, if convicted, or if he pleads guilty of this offense, has to be registered. If the guy wins his case and the state turns out that he was not a sex offender, and the state says you're a sex offender, but sorry, you're not a sex offender, we'll change our registration, I agree there's falsity. But in this hypothetical, you'd have to jump over the qualified immunity problem, which is, for those people who are listening, it's a theory that basically says, due to legal precedents and our case law, we don't hold government actors, including police officers, responsible for violating constitutional rights, usually. And there's a lot of complex exceptions. So, but let's move the facts a little bit more in this hypothetical, right? Let's say, in fact, he did see her. Let's say he's standing in his room. He accidentally looked at her and he had one of those moments like, oh my God, what did I see? And he turned around. Okay. Let's say that she feels violated, but the law in Florida is now different and it requires some touching to be considered an offender. The seeing doesn't count. So the 13-year-old now goes on TikTok. My neighbor's a pervert. He's a predator. He's a sex offender. The state comes in and says, as perverted as it might seem, ma'am, if he saw you, it's not an offense, accidental or otherwise. But now she's already started this campaign, calling him a pervert, a predator. The nuance, the question that's going to be is, does she have a good faith basis to believe that? And if she's calling him a sex offender, that's defamation per se. Most states have what we call per se liability for defamation. For listeners, that means you don't have to prove damages. What you said was so bad because it falls into one of these 3 or 4 categories, in this case, a crime, that we presume the reputation was harmed. So now you see where the battle starts, right? By law, he's not an offender. There's not even a case. Police looked at it and said, no, I'm sorry, he didn't do anything wrong. Your belief is he's a predator. He is a sex offender. It gets dicey. If she said I felt uncomfortable, you can't do anything about that. It's an opinion. I can't prove or disprove somebody's subjective feelings. And that's the test of whether something is a fact or opinion. And so I'm going deep into this example because it's a complex one. And yes, the police are wrong. Journalists are wrong. Websites are wrong, right? What if it's a case of, and I don't know the exact fact pattern, John, that you talked about, but what if it's a case where the platform that does the registry is a private business and they randomly post people on there all the time and they know it. Even if it's for like a petty robbery, they'll put you up as a sex offender. And guess what? You can get your name down, John, but you have to pay us $500. By the way, this has actually happened. There were such websites and they got taken down for extortion.
Wow. John, do you have a follow-up with that?
No. Well, I think in this case, yeah, we're dealing with a state actor. So far, this guest has gotten past the immunity question, because that has come up in hearings and whatnot, and the courts so far have been willing to say, we're not going to toss this out on immunity. There's enough grounds to say there was either gross negligence or enough recklessness that the immunity is qualified, and therefore, no, you're not going to make the qualification. So it's just kind of an interesting way that is played out, and trying to figure out how somebody in that position where, yeah, now you're dealing with a state actor where there are questions that, no, this wasn't just, well, they're in the normal course of their business and they made a mistake, and therefore the immunity will apply, as you're noting. And so, no, there's no liability. Even if there was a wrong done, there's no liability. No, he's gotten past that issue. And so trying to see, well, all right, how can an injustice like this be addressed? And sometimes maybe it can't, but.
Yeah, it's in cases like this where if we can demonstrate, if we can demonstrate all the elements, if we can show our case in chief, there could be substantial damages here, right? Like you said, I mean, how do you rectify that? You were mistakenly believed to be a predator or sex offender, lost your job, lost your relationships. Those are big money cases, as we call them, if you can prove all the elements. And it depends on, again, what the conduct is. Like when a jury looks at this, are they gonna, assuming this is a jury case, are they going to look at the conduct of the individual and say, look, this guy's a pervert, but technically wasn't a sexual predator, didn't meet the requirements of having to be registered? Or is this a case of completely getting blasted and it was just wrong? The website knew they were wrong, or the police knew they were wrong, and you're going to shift sympathies significantly. The other thing, obviously non-monetary wise, is the PR campaign aspect of it. In some of these cases where, let's say, there's no point in suing, or we know it's an uphill battle, or the cost is too great, we try to tell a different side of the story. And that's something you can do now with social media. As bad as social media can be sometimes, you can use it to tell your story and tell the truth and put your narrative out there and put some, push the message, go on podcasts, get interviewed. And
is this something that you all do? You help clients with a PR campaign?
We can help them with it in the sense that we will help scrub the campaign, make sure what you're saying is not going to get you into legal trouble. So we'll work with your PR company. If they're writing content, we'll review it and give you our ideas. And it's kind of nice because our e-commerce practice educates that side of our practice, right? Because we deal with marketing and pushing content, so we know how that works. So that's the capacity with which we can help clients.
Okay. Now I'm gonna share my screen briefly because this all touches up on what I'm about to do, but I want the listening audience to remember we're not a political show. We don't push one side or the other. And Raeed, I'm not asking your political opinion. We just want to talk about this in the context of what we're talking about now. So with that being said, criminal groping case against the ex-New York governor, Andrew Cuomo, formally dismissed. Now we know that a time came up where he was accused from somebody who worked in his office of sexually groping him. And it was big news at one point in time, right? It was huge. And he would be on the show saying on all the news channels, I'm not guilty of this, yada, yada, yada. Then it went away. We know that he had to step down from governor. You haven't heard much of it. But then now we see that the criminal case against him now has been formally dismissed. How can someone in his position now recover from this?
Yeah, this is a great example. So one of the first things, if Governor Cuomo was in my office, sitting across from me like you are, I would say this. I would say, first of all, congrats on your criminal dismissal. That's a big deal. But on the civil side, let's get the facts. Why was it dismissed? Was it political? Was it purely political pressure that, hey, we can't prosecute our governor, it just looks bad? Is this a he said, she said? Is there evidence? And when I say evidence, here's what I'm going back to. You know, these things that we all carry, these things are an evidence machine. They produce evidence faster than anything. Cell phones that I'm holding up, the people who can't see us.
Yeah.
So did they find text messages between Brittany and Andrew that maybe sealed a consensual relationship? And it is true that you can still do non-consensual things to somebody in the confines of a consensual relationship. That is true as well. But is there something contemporaneous with the conduct? Is there video? I don't know in this particular case what happened. I know this is pretty recent, and maybe you know the answer of what the basis was for the dismissal. But yeah, I mean, this happens where people get, it's determined that there's either lack of evidence to prosecute, or it was false. Maybe there was an admission that it was false. And so his options are he could pursue it civilly for defamation. The other thing you could pursue too is a claim called false light. And I meant to mention this when John asked me his question. False light is a claim where the statement could even be true, but it's presenting you in a way that has false implications. And there's the famous case on this, the Hustler magazine case, where there was a model on the cover, and people assumed that the model was modeling naked because she was on the cover of a magazine that has naked models, and she didn't like that because that was not true. So even though it's true that that is her picture on the cover of the magazine, there's a false implication. So there may be a false light claim in the predator example as well, or in the sex offender example. There could be a false light claim here too. Well, maybe he did aggressively grope somebody, but it was consensual. So yeah, it just depends on the facts. I think Andrew Cuomo would need a heck of a press campaign on this one.
And then that's what makes things even more complicated, because in your other scenario with someone posting something on Facebook or TikTok or Twitter, and it's turned out that they lied, you can go back and part of the settlement agreement say, now you have to go back on TikTok and all these social media avenues and say that you basically was lying, right? And that could do a lot for the person who was wrong. But in this particular case, you have a celebrity, so to speak, a public political figure, and it was the news media who was pushing all of this. Now, if this comes out and the accuser lied, the media doesn't have to do that, right? The accused could write a letter, but who's going to publicize it?
Yeah, we see this a lot, particularly in news avenues that do have a political slant, right? And we see it on both sides, Republican, Democratic, whatever, where something comes out, it's found to be totally incorrect, and the news channel, for the sake of their political angle, they're, we get to choose what we report on. We're not gonna say anything. So that,
right. And that's when we had Steve Singler. That's what his gripe was about with the media, because they just flat out refused to produce information that he himself had given them. Now, this is amazing stuff that you're doing. How can people get in contact with you? Do you have a website? Do you have any information that people can find online?
Yeah, absolutely. So you can find us at RM, it's my initials, RM Warner, WARNER law.com. rmwarnerlaw.com. And if you have a question or you have an inquiry, we have a contact us button. You can click that, fill out an intake. But we also put out a lot of free content on our social media channels, like an Instagram. We even have a TikTok, YouTube, and people can subscribe or follow us there. Our handles are all the same, RM Warner Law. And they can even send us a DM and set up a consultation that way as well.
And you take cases, you don't have to, because you're based in Arizona, but you don't have to live in Arizona to get your services?
Correct. Depending on what the issue is, you can be anywhere. You can be anywhere in the world, anywhere in the United States. And we often use local counsel. And if we have to litigate, of course, we have local counsel who's licensed in that jurisdiction, co-counsel with us. But yeah, we help people frequently across the country and across the world.
Wow, that's awesome. That's good stuff. Dr. Cheney, I'm going to give you the last word.
Basically, I thought John's question was very interesting. What about fraud and defamation?
Fraud is the F word of the internet. I was telling Salon this. In any profession, doesn't matter. It could be journalism, medical doctor, lawyer, businessman, businesswoman, entrepreneur, rapper. You put the word fraud in there, and devastating consequences on the internet. That's one of the most viral flowing words, is calling somebody a fraudster, right? And if you're called a fraudster in most jurisdictions, that is considered defamation per se. We don't need proof of damages because typically fraud is a criminal act. It's a level of misconduct that we can presume has damages. Of course, it has to be false. So you have people who defrauded people in a real estate scheme. They deserve to be blasted and exposed. But there are people who use the word fraud very loosely. And I've had lawyers contact me about this and saying, hey, this person sparked a bar investigation because they called me a fraud, when in fact the client was lying, told the lawyer a false story, a false narrative. And it could have been in an injury case, could have been in an immigration case where they lied about marital status or whatever. And they're now pointing fingers at the lawyer, saying this lawyer is a fraudster, after they themselves gave false information to the lawyer.
Wow.
And so we have to come in and evaluate. Do we want to sue? Filing a lawsuit has implications because it brings that issue to the public light. So do you want to be in the public light, Mr. and Mrs. Lawyer? So in short, fraud, yeah, absolutely. We deal with a lot of cases where people are falsely accused of fraud. It can have devastating consequences on your professional reputation. It can cause you to lose licensing, especially in the financial world. And so those are cases that we pay close attention to. But again, if you did defraud somebody or there's some inducement or even a question of it, we probably won't take your case.
Wow. Raees, thanks so much, my man, for coming on and educating us about this very important topic. I think we all know a little bit more now than we did before. Thank you for that. And
my pleasure.
And John Slotty, thank you again for your questions. Dr. Cheney, thank you. And again, subscribe at the red button below and send your comments to info@remuslaw.com or thelegalzone@gmail.com. Thank you, everyone. Thank you again.
Bye-bye.
Alrighty, you all.
Thank you.
Bye-bye.
Thanks for watching our video. For experienced legal services in Washington, D.C., Alabama, and Washington State, visit our website at remuslaw.com or call us at 1-833-329-1799.